Can you discharge your tax debt in a Chapter 13 bankruptcy case? Hi, I'm attorney Leroy Roberson, back to talk about this topic, and I made a video previous to this about discharging tax debt in a Chapter 7 case, and as promised, I said I was going to make one about Chapter 13 cases in discharging tax debt, so here it is. Now, a lot of these things are going to be similar in how to discharge your debt in a Chapter 13 case is a Chapter 7 case, but there are a few procedural differences and a couple different steps that you have to go through. Now, kind of like Chapter 7, in Chapter 13 cases, most of your tax debt is not going to be dischargeable, but there are some exceptions to that rule. And so the first step is just like Chapter 7, they have to be income taxes. And these income taxes have to be based on your income or gross receipts. Now, once you decide that, you have to decide, are the taxes priority or non-priority taxes? And this is a huge distinction because non-priority taxes are the only types of taxes in a Chapter 13 case that you can discharge through the bankruptcy. So that's important. If it's a priority tax or deemed to be a priority tax debt, then it's not going to be dischargeable. Now, another difference in Chapter 7 versus Chapter 13 is even in the worst case scenario, if you can't have the debt discharged in the Chapter 13 bankruptcy, you'll still be allowed to put that payment into the payment plan in a Chapter 13 bankruptcy. So whatever you owe in taxes that you can't discharge, you can put into the plan payment and still pay it off in the 3 to 5 years that the Chapter 13 is going to last. So that is a benefit in Chapter 13 versus Chapter 7 because you can deal with it one way or another in a Chapter 13, whereas in a Chapter 7, if it's not dischargeable, it's just going to stay there. So let's get back to the steps. So like I said, the first step is they have to be income taxes, which are based on income or gross receipts. And now here's how you decide whether a debt is dischargeable or, a non-priority debt or a priority debt. So the first step is that the debt would have had to be due at least 3 years before you file for bankruptcy. So that means if it was due in April of 2017, and this includes all extensions that are possible as well. So whatever extensions you file for that year, if it's April, or let's say you file an extension to file your taxes till October of 2017, then you have to wait out the 3 years. So it'll have to be at least 2020 in October if you filed an extension to make that debt eligible to be discharged. And you would have had to actually filed your tax return at least 2 years before you file for bankruptcy. So you have to have filed those tax returns, and it cannot be a substituted tax return. You had to actually file that tax return at least 2 years before you file for your bankruptcy case. If you don't do that, you're not going to qualify. Next, you had to have not committed fraud or willful aversion in paying your tax debt in order to qualify for a discharge under a Chapter 13. Next thing, the taxes would have had to be assessed at least 240 days before you file for bankruptcy. And most of these things are the same as Chapter 7, but you have to have fallen in all those categories in order for the debt to be considered a non-priority debt. If it doesn't meet those criteria, it's going to be considered a priority tax debt. And there's other priority tax debts as well. We can go over those in more detail if you have any further questions about this, but I just wanted to kind of show you the distinctions and show you that it is possible in both Chapter 7 and Chapter 13 to have tax debts discharged through your bankruptcy case. And so if you want to talk about any of this in more depth, let's get together. Feel free to let me know, and we can talk about all the differences in all of this because I know people may have questions about this. If not, make sure to like and subscribe, and I will see you guys on the next video. Have a great day, guys.